May I please? May I please?
Yes.
Lordship, I beg to mention item number 4, Lordship. I've been requesting my senior friend if it can be taken up tomorrow, Lordship.
Why?
Because due to a PM's visit, Lordship, this very scheme, this is a flagship program of PM under Divine Scheme, Lordship. So it was, Lordship, formally inaugurated by him only, Lordship. So because of that, all the staffs were engaged.
It's going for tomorrow, madam. Already.
No problem. We get it.
On the request of the learned government advocate, S. Tapin, the matter is adjourned today. We have also heard Mr. P. J. the learned senior counsel, assisted by Mr. Dubey. RS. List tomorrow on 13 March.
And Lordship, I'd like to mention item number 7 also, Lordship. Here, Lordship, the RR has been challenged, Lordship, and learned AG will be appearing in this case. If it can be taken over Friday, Lordship.
Friday will not.
It may be listed on Friday, Lordship, may not be taken up.
Monday.
Because AG is coming on Friday.
This court will have problems.
No, sir.
We may not, this division match may not be there.
Okay.
On Friday. You can tell the AG. We'll adjourn it for a week. You can fix a date.
Okay. After a week.
On the request of the learned counsel, Mr. S. Tapin, the matter is adjourned today. List on 18. 18?
Well,
For 1 week.
1 week.
For 1 week.
List after 1 week.
after a week.
May I, Your Lordships? I beg to mention item number 6. I may be allowed to withdraw this matter on being successful.
Item number 6.
Yes, Your Lordship.
The learned counsel, Mr. What is your name?
Counsel, your name?
Your name?
Bata Joel Koyo, BJ Koyo,
BJ.
Koyo, Koyu. Yeah.
Appearing for the appellant submits that he has instructions to withdraw this appeal. I have also heard Mr. P. Tafo, appearing for the respondent.
Standing counsel.
Standing counsel,
Urban Development.
Urban Development Council. Standing counsel, UD
And housing.
and housing. Yes. You are also there.
Yes, I'm for respondent number 1 entry.
So,
You are Aken Ingo.
No, I am. See, smart. I'm for smart.
Right. The appeal stands disposed of on withdrawal accordingly. Accordingly, the appeal stands disposed of on withdrawal.
yes, Mr.
Item
Decker.
number 4, madam. I am appearing for the respondent number 7, madam, the private respondent. Since Lordship has fixed it tomorrow, madam, my name may be recorded. My presence may be recorded.
Heard Mr. PK,
M. Deka, madam.
PK and Deka. Appearing for the respondent number
7.
7. M Deka. M Deka.
Oblige, madam.
Tomorrow. If you have any problem, you can join Mr. Soikia. You can also join if you have any problem through VC. No problem for us.
I will be obliged, madam, if Lordship permits.
VC. No, sir. You can join by VC.
Will join.
But you will have to clarify.
Yes,
Because he has raised very serious allegations. Have you filed an affidavit?
we have not filed yet.
We would have loved if you had filed an affidavit.
I also, madam.
Where is Mr. Tapin? Can you get hold of Mr. Tapin? Mr. Tapin, there is serious allegations against him also. So we would like an affidavit on his behalf. So let him file an affidavit. We can have this matter on Monday.
In that case, my lord, Lordship has observed in the last order, my lord, for consideration of the interim prayer. as well.
They will do it on
Lordship
Monday.
will till Monday, no problem. But my lord, the further, my lord, continuation of the work may be, my lord, state.
Let us, 3 days, 4 days, what will you do? Let him file an affidavit by Friday or Thursday.
Since the government is producing the filing an affidavit, direction was then to file.
You are
an-
filing an affidavit, Mr. Tapin. I don't know. There is not a filing an affidavit.
No,
That's the
madam,
problem.
the last order.
We had directed, but I don't think so. He'll be able to file an affidavit by tomorrow.
Madam,
If we will have it on Monday, so let them both file an affidavit in mathematics. That will be better. The stand would be on record. So,
Today is Tuesday, my lord. In a week's time, my lord.
Monday, not more than that.
Madam, till then, at least, madam, the works should be, madam, is an
We
appointment.
will,
madam,
we,
from the
we have already observed, we will see to that. On that day, we will finish it off. If the affidavits are on record. Because otherwise, again, we will have to draw presumptions on the basis of the records. So let them bring their stand on record. We'll finish it off.
Let me on Friday in that case, madam.
Friday, this bench may not be there. That's the problem. Monday.
Monday, perhaps this
Monday.
bench will also be not there, I think.
But there will be a revision.
There
bench.
will be
There will be
a bench that is there. madam.
We can't say we may also
Lordship,
continue.
that is there.
It was not sign on to Kumbare Koidu.
Monday.
Oh, sorry.
18.
Respondents have to file their affidavit.
No, it will
By
arrive.
Friday.
Both the respondents are to file affidavits
By
by
Friday.
Friday,
15.
15.
Mr. Nega, Mr. Tapin, by 15, you file
Hello.
your affidavits. With copy to Mr. Please, this is a very serious allegation. We'll have to have that affidavit. You also file your affidavit. Clarify what is the, only to that extent. If you file a limited affidavit, that will.
We'll file a limited affidavit only to the allegations.
Allegations.
Madam, in case, madam, they don't file, at least, madam, my consideration of my interim prayer, that observation.
In the event the respondents fail to file affidavits, the prayer for interim relief shall be considered
On the basis of.
on the basis of the materials available with the report. Eighteen.
80.
May I please one? In this case, I've been instructed by the council that to take another date for the matter because
You cannot come one day, stay away for another 2 days and again come one day. We will not permit that. Hear the matter today. Last
No, no.
occasion you were not here.
because,
Before that also.
because on the
I
last
find
occasion,
that
I did
few
not
days-
receive any instructions from them, Your Honor. And today as well, I had to call them and ask in the morning, and I've been asked to appear and take another date. They'll appear through VC. Since they are from Guwahati, they will not be able to appear.
We'll give them a last.
My lord.
Next time, no appearance. Don't pray for an adjournment. We'll let this.
MS.
T.Y. Bhutia.
Why put here?
T.Y. Bhutia. Appearing for the petitioner praised for an adjournment on the ground that the learned conducting counsel. Who is the conducting counsel?
Dr. Sharaf.
Yes.
A. Sharaf.
Dr. A. Saraf, the learned senior counsel, is not available today. I have also heard Mr. M. Kato
My lord.
appearing for the respondent,
Union.
Union of India. The prayer for adjournment is allowed for the last time.
As a last.
List again on. When do you want it?
Any next day the DB sits now, because they'll be appearing through VC.
20? 20?
20.
List on 20.
My lord.
March.
Deep level.
Item number 5. LCR not received.
Not yet, Your Lordship.
Oh, heard MS
Non-appears for it.
non-appears for the, you are for appellant. I'm the appellant. Heard Mr. Titapak appearing for the appellant. Heard MS Tijini, the learned additional people for the state of Arunachal Pradesh. LCR not received. It's not.
It's a second.
Seen the office note dated 07/03/2024. Office is directed to procure the LCR. List after 4 weeks.
Declare.
Item number 8 and 9.
Yes.
Your Lordship, this matter is through BC Lordship. Mr. Mojumdar's Lordship is appearing Lordship.
It's not here.
Lordship.
I'm there.
Yes, Lordship. Yes.
Oh,
Mudunda has come.
This is an IA. Lordship, am I audible, madam?
yeah.
Yes.
This is IA we have filed because there is an urgency in the matter. In fact, what has happened, the petitioner was working in the Geology and Mining Department. He submitted an application for his resignation so as to enable him to contest the ensuing assembly election. What is happening in Nepal, while it is not known, the state government is opposing, although there is nothing on record to show that any disciplinary proceeding is pending against him or any vigilance or any other matter pending against him. In spite of that, his resignation is not been accepted. Now, earlier also, one NOC was issued by the Deputy Commissioner that was without any reason cancelled. This one directed that the authority will pass a fresh order within 3 months. Long ago, this 3 months time has expired. Now, what is happening is, my lord, anytime the notification will be issued by the Election Commission and the date for submission of nomination paper will be there. And my lord, it appears, my lord, the state government has filed the appeal. How the state government is agreed by such order, my lord, when state government has not in the writ proceedings said anywhere that any disciplinary proceeding is pending against me or any other matter. There are two OMs, my lord, of the government of Arunachal Pradesh, which says that there are reasons on which the my lord, the resignation cannot be accepted. One, if the post he is holding is of importance, that is not there. Nowhere there is anything like that. Secondly, my lord, if I am under suspension, that is also not there. For what reason they are withholding, it is not known. Now, when the Honorable Single Judge has passed an order that since a period of 3 months has expired and you have not taken any action, and there is nothing on record to show that there is any disciplinary proceedings pending against him, or he is under suspension, or there is any other criminal investigation pending against him. In spite of that, this resignation is not being accepted. Now, it appears that a third force is working behind the whole thing. And the state government, for nothing, is withholding the acceptance of the resignation so as to ensure that the third force, which is working against me to prevent me from contesting the election, succeeds in this entire effort, my lord. There is absolutely no reason for which this writ appeal was filed with the state government. How the state government is aggrieved, nowhere it is mentioned in the writ appeal, but they have filed the appeal. Now the interim order has been passed, interim order is there, and if the interim order continues, my lord, a day will come, my petition will become infructuous. That is the reason, my lord, we have filed this IA for vacating the interim order, so that, my lord, the petitioner can contest the election, my lord. If they are still aggrieved.
Yes, Mr. Topic. Last time we had required you to show us as to how you had processed this application.
No.
Yes, I received the copy, Lordship.
What is it?
IA, Lordship.
No, forget the IA. IA we are not voted. We are voted with the main petition.
Lordship, no.
How was that application processed? Because in your written statement, in your affidavit in the before the learned single judge,
Lordship.
you have said that you have no objection in him going for releasing. But certain formalities are to be fulfilled. So we wanted to know what steps you have. I think you remember on the last occasion.
Yeah,
That's the ground we passed the stay order.
I remember. Yes, I have communicated to the department, Lordship. So we have not yet.
No, it's an appeal. Appeal is by you.
Yes.
We are not concerned with the IA. We are not even looking into the IA.
Not in the IA, Lordship. Lordship has suggested on last occasion, Lordship. Bring on record all those communication, Lordship. I have communicated to them, Lordship. Then I will.
Because say the urgency expressed here is
Correct.
there is something.
Let us fix on Monday for final discussion.
No. And Mr. Majumdar,
Because it has been listed because
Mr. Majumdar, am I audible to you, Mr. Majumdar?
Yes, well, I'm hearing a lot.
The learned single judge proceeded in the matter, holding that this to be an application for voluntary retirement.
Well, that part I understand. Well, even assuming that part is
Then,
not there.
if that be so, without an acceptance by the government, how can the resignation come into force?
Well,
And you have not questioned the matter in that line before the honorable single judge.
I have it is my honorable single judge has proceeded slightly in a different direction. I am not on that, my lord. What I am saying is, my lord, ultimately the honorable court has held, single judge has held that there is no material. If your lordship goes to the judgment of the honorable single judge, my lordship will find it paragraph 12. Paragraph 12 of the
20?
judgment. Paragraph 12 of the single judge's judgment, my lord, page 15. 1-5. Of the retable, my lord. Paragraph 12, my lord, it's a part of the judgment passed by one single judge. On a lordship has got, my lord.
On a specific query.
On a specific query by this court, the learned state counsel, however, submits that he does not have any instruction as to whether there is any departmental proceeding pending or initiated against the petitioner. The act of resignation by an employee may not be an one-way traffic, and therefore the rules governing the field has laid down a certain period for such acceptance before which the employer would be in a position to reject such offer resignation, which in this case does not appear to have been done.
So kindly take us to that rule. That rule which specifies that 3 months period is to be within 3 months, the resignation has to be either accepted or rejected.
My lord, there is no rule as such, but then we have got OMs, my lord, which we have annexed.
Yes.
They have, one is at page 55.
Okay.
Here, my lordship, kindly see if your lordship has got page 55, my lord.
Fine.
Where the government Roman 1, my lord, where the government servant concerned is engaged on a work of importance.
But Mr. Majumdar, the case before the honorable single judge was not projected in this lines. It was projected in the line of a voluntary retirement, 20 years.
My lord, I understand what I am saying, because ultimately, or the order that was passed is the government is sitting over the matter without any reason, and there are.
That is why we required the government council to produce before us the manner in which your application was processed.
Absolutely, my lord. And as your lordships are now saying that they have filed the writ appeal, they should have come up with all these documents before obtaining an order of stay. Now they are saying that after we have filed the appeal, we have obtained the interim order, now we want to produce the documents.
Mr. Tamin, tomorrow, we will only that file how his application was processed, because you say that the vigilance clearance was not required. We want to know, because the vigilance clearance is for you to obtain from the documents that are there on record.
No, this correct.
Fine, give it to us.
Can you ask them?
No, tomorrow.
Because actually, I was under the impression that today the I would be.
No, I am. We are not concerned with the I.
This matter has been listed because I has been filed.
Lordship will
No.
Well, the whole endeavor is to delay the matter so that the petitioner cannot file his nomination paper. How the state is in?
Let that allegation not be.
Today is Tuesday, Lordship. Day after tomorrow, Thursday.
Mr. Majumdar, Thursday.
Third day after tomorrow, man. Yes. Yes.
On the prayer made on behalf of on prayer made by Mr. T. Tapin, learned counsel appearing for the appellants, list this matter again on Thursday as the list this matter again on Thursday. So Mr. Tapin on the next day shall produce the relevant records to demonstrate the manner in which the resignation application of the petitioner dated 8/9/2023 was processed. 23.
My lord.
8/9/23 was
My lord.
processed by the respondent authorities. Full stop. In the event such details are not produced, adverse inference as may be required to be drawn in the matter would be so drawn by this court.
Madam, may I pray, since your lordship has asked them to produce those relevant documents also, on day after tomorrow, when the matter may be taken up for final disposal, I'll be highly obliged.
Let's see.
Very small matter, my lord, it's a matter of resignation. They are preventing my resignation for no reason whatsoever.
On Thursday, we will pass appropriate orders. Don't worry.
My lord, deeply obliged.
Much obliged.
Yes, Your Lordship. We filed this IA for condonation of delay in filing.
Yeah, we
the
will go. Issue notice today.
Lordship.
Hard MS,
Samla.
Yes. Sumila.
S. Samila.
No, so.
Oh, hard MS Samila. Appearing for the petition. Issue notice to the respondents. The petitioner shall take steps for service of notice upon the respondents by registered posted AD.
Government says. Okay.
You are appearing.
Yes.
Then hard MS S. Samila. Appearing for the petitioner. Hard MS. Appearing for
1, 2, 3, and 7.
for the respondents 1, 2, 3, and 7.
Yes.
Hard Mr. You are also appearing. Hard Mr. So-and-so. Appearing for the respondents.
Experience for the respondents number?
4, 5, 6.
Oh, no, sorry. I've got 1. I'm 4, 5, 1, 6. And 2, 3, and 7.
You are for?
Madam, you are for?
2, 3, and 7.
2, 3, and 7. And you are for 1, 4, 5, and 6. Issue notice, no formal notice is required to be sent. As the learned councils representing the respondents have accepted notice. Least after 4 weeks. You want to file any affidavit? Objection? Aye.
Not.
After 4 weeks.
Obliged.
Lordship, if this matter be fixed on 21st, Your Lordship.
21st.
Yes.
List on 21st March.
Deeply.
Lies.
Item number 1.
Your Lordship, may we pass over this matter for time being, Your Lordship.
For the time being.
Yes,
Who is coming?
See Modi, Your Lordship.
Acha, okay.
Bless you.
Item number 25. Yes. Item number 25.
Yes, 25, my lords, I am appearing in this.
Yes, you are appearing for a petitioner.
Yes, my lords, I am appearing for the petitioner, my lords. Before adverting to the grounds as to why I am challenging the impugned FIR, my lords, the facts of the cases, my lords, are that the petitioner number 1 and the respondent number 2, my lords, they entered into the marriage in the year 2018, my lords. In 2019, my lords, they migrated to Delhi, New Delhi, my lords. And in 2019 only, my lords, from New Delhi, they went to Srinagar, Jammu and Kashmir, my lords.
Yes.
In 2019 only, they entered into the Nikah ceremony at Dal Lake, Srinagar, my lords. That has been reflected by the by the respondent number 2 in her petition, which she has filed under Domestic Violence Act before the Court of Chief Judicial Magistrate, Srinagar, my lords. Now, my lords, what happened in 2020? The things got messy between the parties, my lords. In 2022, my lords, she approached the Court of Chief Judicial Magistrate, Srinagar, my lords, with a complaint under Domestic Violence Act, my lords. All the essential ingredients that has to be included while making out a prima facie case that was established. The court took the cognizance of the matter, my lords, and I was directed to pay an interim maintenance, ex parte interim maintenance of 17,000, my lords. I was paying that. Later on, she abandoned the proceedings, my lords. The domestic violence petition got dismissed, my lords. Then she filed the restoration application, my lords, which eventually was allowed, my lords. Now, then she was directed to lead the evidence. She led the evidence. Her cross-examination was done. Then again, she left the proceedings, my lords.
Yes.
Now, my lords, so what happened in 2023, my lords? Till 2023, she was residing at Srinagar, Jammu and Kashmir, my lords. In November 2023, she left the Jammu and Kashmir, my lords, went to Arunachal Pradesh, my lords. Now, what has happened, my lords? On 1st of March 2024, my lords, a written complaint is being submitted before the concerned police station, my lords, on the same set of facts, my lords, which she has narrated in her domestic violence petition before the Court of Chief Judicial Magistrate, Srinagar, my lords. And my lords, if we go through the contents of the FIR, my lords, it reflects that at no point of time, my lords, they have ever resided at Arunachal Pradesh, my lords. So, my lords, in my humble opinion, my first ground, my lords, is that the police station, any police station in Arunachal Pradesh does not have jurisdiction to investigate or register an FIR against me, my lords. If there is anything that, if the violence has been unleashed upon her, as per her petition, that has been unleashed upon her in Srinagar, Jammu and Kashmir, my lord. So, my lords, any police station in Srinagar, Jammu and Kashmir have the jurisdiction to register FIR against me, my lord. Not any police station in Arunachal Pradesh, my lords. And my lords, may kindly see page 30, para number 8, my lords. What she is narrating. Para number 8, last but third line, my lords. The applicant number 1 has also approached the woman police station, Rambagh, Srinagar, but without any relief, my lords. So earlier she went to the police station in Srinagar. FIR was not registered. She filed a domestic violence petition against me, my lords. She was directed to lead the evidence, my lords. She abandoned proceedings, my lords, went back to the Arunachal Pradesh, my lords. Now registered an FIR against me there, my lords. Now, apart from that, my lords, she has narrated the domestic violence. This violence has been unleashed upon me in 2022 and 2023, my lords. Now, my lords, if the violence is unleashed upon her in around 2 years back, my lord, how can an FIR be registered right now against me, my lords? That is another ground, my lords. Now, my lords, I say that the essential ingredients in order to carve out a case, my lords, prima facie against me, are not established, my lords. And my lords, the respondent number 2 in her petition while filing before the Chief Judicial Magistrate, my lords, she has narrated that the petitioner number 2 has not allowed the petitioner number 1 and the respondent number 2 inside her house. And she was living in a rental accommodation at Dal Lake, Srinagar, my lords. So once she was not allowed to reside me, once nothing is established prima facie against me, how can an FIR be registered against me, my lords? Now, my lords, I say there is a gap of around 2 years in filing and registering the FIR, my lords, which is not, of course, the mandate of the law, my lords. And my lords, I say, why she has registered an FIR against me, my lords, the simple answer to that, my lords, is harassment, my lords. I rely on a judgment passed by this court only, my lords, in 2020, my lords. My lord, the assistant counsel over there can forward the copy.
Yes, where is the judgment?
Yes, Dhananjay Biswas. Dhananjay Biswas, my lords. This is the judgment, my lords. My lords, may kindly see the last page, para 31 of the judgment, my lords.
Para
Para
31.
31 of the judgment, my lords.
Yes.
Yes. Thus, this court is of the unhesitant view that the institution of the criminal prosecution against the accused person in GR case number such and such through the FIR by the informant is not for the intention which can be termed bona fide. Rather, it goes to show that the launching of the criminal prosecution by the informant through the FIR is to use it as an instrument of the harassment and to wreak vengeance on the accused person, my lord. This is my ground, my lord. My lord, the police stations or the criminal cases are not meant to harass the other party, my lord. My lord, it may be true that the violence might have been unleashed upon her, but she has already approached the court, my lord. Now, my lords, another ground I say, the Lalita Kumari judgment, my lords. Supreme Court, my lords, what I understood from that judgment, my lords, that before registering the FIR, especially in the matrimonial, no, copy is not
Lalita
there.
Kumari judgment. Lalita Kumari judgment is available.
No, my lords. I'm just reflecting. I'm just reflecting for
Yes,
my
yes.
lords. Yes, my lords. What I have learned from that judgment, my lords, is that once you register an FIR, especially in the matrimonial cases, my lord, a preliminary investigation have to be conducted, my lord, which has not been done in this case. Have the preliminary investigation been conducted, my lord, then impugned FIR won't have been registered against me, my lord. And my lords, I rely on the other judgment, my lords. It has been passed by the High Court of Jammu and Kashmir, my lords. I'm just giving the copy of that judgment as well, my lords. For my lords, kind perusal, my lords.
Yes.
Yes, my lords. My lords, this judgment reflects what has been narrated in Lalita Kumari judgment, my lords. My lords, we go to the contents. My lords, it says that before registering an FIR, a preliminary investigation have to be conducted, my lords, which has not been done in my case, my lords. And my lords, apart from that, my lords, we say whether section 494, because FIR has been registered against me 498A, 494 and 506, my lords. If 494 is made out or not, my lords, admittedly, by virtue of her petition before the Chief Judicial Magistrate Srinagar, my lords, she has said that I have converted to the religion of the Islam. Now, once you are a Muslim, the Shariat Act gets applicable, which is applicable all over the country, my lords. Now, bigamy against the husband who is a preacher of the Islam, my lords, that the essential ingredients are missing out, my lords. It cannot be read out against me then, my lords. So, my lords, I say, let the other side file the objection, but in the meantime, my lords, this impugned FIR has to be stayed because there are very serious flaws in registering FIR, in investigating the FIR, my lords. Yes, my lords.
Okay. At this stage, I will issue notice now.
But my lords, interim protection, my lords, my lords, I am from Srinagar, my lord, Jammu and Kashmir. It's around 4,000 kilometers, my lords. Prima facie, it's a tool of harassment against.
So, in prayer is concerned, I can only ask police not to take any coercive action against you.
Lordship, may I submit, Lordship?
Yes.
Lordship, here, Lordship, he has the right to, Lordship, lodge FIR, Lordship. I am submitting, Lordship, one judgment, Lordship. Lordship. Rupali Devi versus the state of UP, which is recorded for the 9/4/2019. Lordship, I'll furnish the copy later on, Lordship. I am not. Lordship, here, Lordship, para 9, Lordship. It's stated that, Lordship, here, when the Lordship wife has forced to, Lordship, when they
When the wife forced to leave and go to her parental home, no overact of cruelty by husband or his family members in the wife parental home where the wife has taken shelter. In the normal course, under section 177, the court within whose jurisdiction the offence is committed would have the power and authority to take cognizance of the offence in question. However, under section 179, if an offence is committed partly in one place and partly in another, or if the offence is continuing offence, lordship, or where the consequences of a criminal act result in an offence being committed at another place, court at that place will be competent to take cognizance. Lordship, here, lordship, we once go through the lordship, the FR of the lordship, which is lodged here, lordship, in the Arunachal Pradesh, lordship. May lordship will look in the FR, lordship.
Page number?
Page number 24, lordship, last para. It starts from last para, lordship. Page number 24, the FR, lordship, different. May lordship. Lordship, here, lordship.
Very long FI.
Is lordship. Let be no other option on the advice of a local lawyer, see paper domestic violence case in the Honorable Court of Chief Judicial Magistrate in Srinagar in June 2022. Basically for protection to pay the rentals of the rented accommodation and maintenance. It is crucial to note that despite the Honorable Court's order, the accused number 1 has failed to adhere to the directive to pay the monthly maintenance amount, thereby leaving her and their minor son in a destitute state without any financial support. After the DB case was filed against the accused number 1, he proposed a settlement to avoid a legal case, leading us to return to Rowing on 13/6/2022. At Rowing, he demanded a car, as her parents were already dealing with the expenses of her father's cancer treatment. She was forced to borrow a loan of rupees 3 lakhs from her cousin, this to meet his demand for a car. In 2022, he consistently pressured her to seek money from her parents, despite knowing that they were already distressed with the cancer treatment, threatening to end their marriage if his demands were not met. This has resulted in a substantial burden of loans on her shoulders. Accused number 1 was also misappropriating the earnings from dhaba of her father, and when she asked him to refrain from such things, he got furious and he slapped her hard on her face. It was intervened by her mother and stopped him from further hurting of her in the month of July 2022. In August 2022, he abandoned them again. On March 7, 2023, he, along with her son, returned to Srinagar as he was not attending any of her calls. Accused number 1, which is the accused lordship, refused to accept her and their son and to maintain them, who was fully supported by accused number 2. They bluntly told her, accused number 2 is the mother-in-law, lordship. They bluntly told her to go back to her parents, but she refused to do so and preferred to stay there. But Srinagar held a meeting on her behest at the Abu Bakr Masjid meeting hall, where accused number 1 found guilty and his property and to move different place. Sold his property, and where the accused number 1 sold his property and moved to a different place, abandoning them. Accused number 1 had initially asserted to have only have her as his wife. However, to her shock during the meeting, it was disclosed that he is living with another wife and has even fathered a child about 6 months younger than her son. This revelation has left her feeling deceived, as he breached her trust, subjected her to harassment, and made her life thoroughly miserable, despite her family's sincere attempt to meet their dowry demands. She had been subjected to persistent physical assault, mental torture, and threat from him. Notwithstanding her initial resilience against various challenges, she eventually had to give up and was compelled to return to her parents' house in Rowing on 23rd November 2023. Accordingly, on receipt of written FIR, register a case, this is the lordship for the investigation. Lordship, here, lordship, it appears that lordship, however, this maintenance case was there, lordship, it was there, but he was not compliant, lordship. So lordship, being aggrieved, lordship, she against lordship lodged the FIR, lordship. As per this judgment, lordship, if the lordship discontinue of this kind of lordship harassment, lordship, she can lodge anywhere, lordship. If the competent court can lordship register her case and can follow the procedure also, lordship. So lordship, at this step, notice may be issued upon the respondent number 2 also, lordship. Only notice may be issued, lordship.
No, my lords, once.
At the learned counsel, Mr.
Yes.
Okay, I will issue notice. What is your name?
No, my lords, Hazim Qureshi, my lords. But before, my lords, may kindly hear me just 1 minute, my lords. My lords, I see if the contents of the FIR are true and correct. Let's assume they are true and correct. My lords, admittedly, all the things has happened in 2022 and 2023, my lords. How can an FIR be registered in 2024, my lords, against me? That too after a gap of 2 years, my lords.
Okay,
Now, my
this
lords,
is,
they,
I will issue notice only. I
my
will issue
lords,
notice only. I will ask police not to take any course of action against you.
but my lords, I am from
Hard
Srinagar.
Lordship, investigation
It's around-
need not be lordship, stay lordship, because lordship, CD may be called for lordship.
Investigation is
No,
not
my
going
lords.
to be stopped.
Lordship.
I will ask police not to take any course of action. against
Lordship.
But my lords, the problem is that I am from Srinagar, my lords. I have to travel around 4,000 kilometers along with my ailing mother, my lords, who too has been made accused in this. Now, my lord, the problem is the heart ill, old aged father is only there in my home, who will take
Okay,
care of.
but I will ask the police not to take any course of action against you.
But
I
my
think
lords,
that
I
will-
have
that
to
will be
make
sufficient.
then myself available before the police station, my lords.
No, that will not be required. That will not be
Okay,
required.
fine. If that thing is clear in this petty.
Otherwise, he may file lordship AB also, lordship. If apprehension of the arrest, he can file AB at any time. Point of time.
Heard Mr. H. Qureshi on video conferencing. Heard MS H. Lakshmi, the learned additional PB for a state board national police. Issue notice to the respondents.
Respondent number 2, lordship.
No formal notice is required to be sent to the respondent number 1, as because MS Lakshmi has accepted notice. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post with AD. Least after 4 weeks till returnable date. The police, in respect of FIR number 08 of 2024, police of what is the police station?
Going.
Rowing case.
Rowing police station. Till returnable date, the Rowing police station, in respect of FIR number 08 of 2024, shall not take any coercive action against the present 2 petitioners, Adil Siddiq Khan and Halima Siddiq Khan.
Lordship, it can be lordship, carried out his investigation process. Lordship. Carried out the investigation process, lordship.
Investigation will go on,
Lordship.
but no coercive action shall be taken against these petitioners.
My lords,
CD may be called for
kindly-
lordship.
My lords, may kindly reflect that I am not required personally for the investigation. If they want, yes, my lords.
The petitioners, Adil Siddiq Khan and Halima Siddiq Khan, are not required to be present before police till returnable date.
Lordship, how then the investigation will go on, lordship, if he's not?
I'm highly thankful, my
Let them
lords.
investigate the matter, least after 4 weeks. 4 weeks
I'm highly
after
thankful,
decision.
my lords. Highly obliged, my lords.
Okay.
Thankful, my lords.
Then lordship, CD may be called for lordship on the next attempt.
CD is not required now. Let the respondent number 2 appear first.
Lordship.
After that.
Lordship. Obliged, lordship.
Item number 26.
Please, Your Lordship.
Yes.
It's a crossing of a proceeding, my lord, presently pending in the session court, my lord, at UPR. My lord, the
trial is going on.
Trial is going on, my lord. I'm challenging the, my lord, charge frame, my lord, under section 376-417, my lord, order dated 27/10/2022. My lord, the allegation.
First of all, I will issue notice and I will stay the proceeding. Heard the learned senior counsel, Mr. P. J. Seke, assisted by Mr. R. Mishra, R.C. Mishra, appearing for the petitioner. Heard MS H. Lakshmi, the Lara State of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to the respondent number 1, as because MS Lakshmi has accepted notice. Extra copy of the petition shall be provided to her. The petitioner shall take steps for service of notice upon the respondent number 2 by registered post to AD. Least after 4 weeks till returnable date. The further proceeding of sessions case number 07 of 2021 pending in the court of the Sessions Judge UPR shall remain stayed.
Okay.
Item number 27. Who is for item number 27?
Madam, we pass over for time being.
Who is coming?
My senior Titaba.
Titaba coming.
Yes. Yes.
Item number 20.
Same, your lordship.
Hmm?
28th also. 28th also.
28 also.
Yes, your
Taba
lordship.
is there.
Yes.
Oh, you have come. Then bring to me. 27 and 28.
27.
27.
Yes, Your Lordship, criminal petition.
Yes, Mr. Taba.
Yes, Mayor, please, Lordship. Lordship, this is an application filed under section 482 of CRPC for quashing of the proceeding of Sagali PS case number.
What are the sections?
Sections is
379.
379, read with 511 IPC, Lordship.
Attempt of theft.
Yes, Lordship. So they have already,
This is a common petition,
yes, Lordship,
joint petition.
joint petition, but
Your Lordship, here my only concern is, Your Lordship, is well aware that for 482 for squaring, Your Lordship, on the basis of settlement, the fundamental rule is the party must settle the matter among themselves. And secondly, they have to approach this court to all together. And then, Your Lordship, the gravity of the offense. Now, Your Lordship, the first part, all the parties, Your Lordship may directly come to section, this page number 27, that is the FIR.
27.
Yes, Your Lordship. I will, Your Lordship, try to demonstrate that the property belongs to BSNL.
Oh, it's also.
Property belongs to BSNL and the caretaker has lodged an FIR.
Oh,
And the material were seized. All the material which were supposed to be used for committing theft has been seized by the investigation authority. All has been recovered and the matter has been charge sheeted. Now, Your Lordship, the issue here is whether the caretaker of the BSNL company can enter into an agreement
yes.
where the property of BSNL is involved.
Mr. Tawa,
Lordship,
it will be difficult for you because property belongs to BSNL.
Lordship,
So BSNL should come.
Yes,
Lordship. But Lordship, again, Lordship, since the matter has been settled between the parties, and Lordship, if the case,
It is to be settled between with BSNL.
Lordship, but
Settlement should be with BSNL.
here in this case, the prosecution has failed to examine any of the authorities of BSNL other than the informant, Lordship. And Lordship, if this case goes for trial, since the matter has been already settled, so there is no any, there may not be any chance of conviction of this accused person, as because they have already settled and none of the BSNL authorities has been made as a party by the prosecution in the investigation. So Lordship, considering the fact that if the case goes for trial also, there may not be
Okay,
any,
Mr. Taba,
Lordship,
it will be listed on some other day.
Lordship.
You just write, list the matter on 21st March.
Lordship, till then the proceeding may be Lordship state,
That will be considered later on.
Lordship.
Lordship.
What about 2028?
Yes, Lordship. This is a Lordship petition under 482 challenging the charge framed by the learned Chief Judicial Magistrate Court against the petitioner.
Charge frame.
Yes, Lordship.
Under which section?
Charge has been framed under section
Section 3 of PDPP Act.
Lordship and 392 part 2, Lordship. Lordship, here the case is that
What is PDPP Act?
prevention of damage of public property.
Oh,
May I read the FIR, Lordship?
page number?
Lordship. Lordship, the case has been charge sheeted, already charge sheeted. So I'm reading the charge sheet. Lordship, page number 18.
18.
Yes, Lordship. The brief fact of the case is that on 28/11/2017 at about 916 hours, a written complaint has been received from one Sri Subodh Datta, age so-and-so, son of so-and-so, permanent resident of so-and-so, to the effect that on 28/11/2016, at about 5 a.m., while he was on a morning walk, some miscreants suddenly obstructed and assaulted him after demanding money from him. They were burning tires at RCC bridge of Chandanagar, Itanagar. They also tried to lay him down on the ground by snatching money from his pocket. In the meantime, police party arrived and caught some of them, while some fled away from the scene. Later on, they were identified as member of Arunachal Youth Organization, imposing 12 hours ban. The apprehended boys revealed that they were engaged by Sri Gyogi Talar, President IO, and Kalingta Singh, Secretary IO. On receipt of FIR, Itanagar Police case number 326/16 under section 188, 393/34 IPC, read with section 3 of Public Property Prevention of Damage Act 1985 and investigation taken up. During investigation, the complainant Sri Subodh Datta was medically examined at RK Mission Hospital by Dr. T. Malin, whereas Dr. opined that.
Okay, Mr. Taba, I will issue notice now. I
Lordship.
will stay the proceeding.
Lordship.
Heard Mr. T. Taba appearing for the petitioner. Heard Mr. G. Tado, the additional PP for the state of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to respondent number 1. That's because Mr. Tado has accepted notice. Extra copy of the petition shall be provided to you.
Lordship.
The petitioner shall take steps for service of notice upon the respondent number 2 by registered postage AG, least after 4 weeks. Till returnable date, the further proceeding of what is the case number?
That is, Lordship, this is case number is Lordship. Just a minute.
You have not mentioned here in the petition.
Lordship, I have mentioned.
GR number
GR case number
813
813
of 2016.
2016.
Yes, Lordship.
Pending in the court of the Chief Judicial
Chief Judicial Magistrate UPR.
Shall remain stayed.
Deeply obliged.
Yes, AB.
Yes, Your Lordship. Your Lordship, I have been issued a notice under section 41A of the CRPC, wherein I have been called to appear before the police station, Your Lordship. Your Lordship, the fact of the case is that an FIR was registered under section 24A of the Arms Act 1969 in Anini police station, wherein the main accused was arrested.
Where is the FIR?
FIR copy is
Page number?
Your Lordship, 10. Page number 10, Your Lordship. 10, Your Lordship.
Page number 10.
10, Your Lordship. May I read, Your Lordship? It is to inform that the information was received from a reliable source that one Sri Jokoro Mo, son of Sri Atoga Mo of village POPS Anini, Dibang Valley district, illegal arms in his possession. Accordingly, as per the information itself, along with Sri Navam Rikam, DSP Anini, SI, W. Wangrong, OC, PS Anini, with PS Ready Party, headed for the residence of the above mentioned person to conduct search. On arrival at the said residence of alleged person, he was not available at his home, but he was later found at his relative's house. Accordingly, he was brought at his residence and he was informed about the purpose of our visit. A search memo under section such and such served to him, and he was thoroughly briefed about the search procedure. Subsequently, a search memo was handed to him. Accordingly, a search was conducted with free ingress. During search at his house, the below mentioned articles were found. And accordingly, it was seized on the spot. The seized articles are as follows: Call positive police, 38 pistol, 2 38 mm live rounds, 10 nose, 22 pistol with magazine, 22 mm live. And serial number 5, made in England revolver. My concern in this petition is about this serial number 5, that is made in England revolver. I'll come to that. Next, 9 mm live rounds, 9 empty cartridges, 9 mm defective rounds, empty cartridges, live rounds, 32 mm, 4 SBL gun, shoulder holder. Thereafter, the above mentioned person was apprehended and brought at PS for further interrogation into the matter. You know, if the main accused has been enlarged on bail, but in my case,
Why are you apprehending arrest?
Your Worship, because the sections they have, they have issued a notice under section 41A saying that I have committed a cognizable offense, Your Worship.
Okay, case diary will be required here.
Yes, Your Lordship.
Yes, Your Lordship.
I will call the case diary. Heard, Mr.
Your Lordship, I have an interim prayer, Your Lordship. Your Lordship, my contention is that the sections which they have invoked does not attract, because the pistol, the England-made pistol, is an old one. It has become obsolete and it's of kind of an antique piece. Your Lordship may come to section 45C of the Arms Act 1959, Your Lordship.
That is not required now.
Yes, Your Lordship.
Case diary will be required first. What is your name?
Emily, Your Lordship.
Heard, Mr. N.
Emily.
N. Millie.
Emily.
Appearing for a petitioner. Heard, Mr. T. Ete. With the additional PP for a state of bonus to this. Call for the case diary. When it will come?
Your Lordship, let it be listed on 19th, Your Lordship.
List on 19.
Deeply obliged, Your Lordship.
Yes.
This is also there is an application filed by the informant and the accused man. In connection with the Jenkins PS case number 5 of 2023. Here in this case, my lord, the FIR has been lost by my wife, accused of petitioner number 2 before the lordship as an informant. And lordship may kindly come to the page number.
Is it a joint petition?
Yes, this is the joint petition. In view of the, my lord, in view of the FIR, the matter has been disposed in the form of the, my lord, customary court, in the form of the Kebaman. After lodging of the FIR, while the investigation was on, at the same time, my lord, the petitioner number 2 had approached to the, my lord, village council. Therefore, my lord, decision has taken, and I have been imposed some, my lord, penalty in the capacity of the village, my lord, customary court. Therefore, my lord, in view of that, petitioner number 2 is also, my lord, not ready to pursue the case, my lord. Since we are the, my lord, legal spouse, despite that, as a petitioner number 1, I have remarried. Because of that, there was a certain problem between us. But despite of that, for the sake of the 12 years old son, out of our wedlock, we have decided to settle the matter amicably, my lord, in front of the village authority. I will take the lordship to the decision in page number 22.
Kebang decision.
Kebang decision. My lord, got it? My lord, in view of the FIR, my lord, this decision was taken. Today on the 4/2/2024, the Gamburo of the Rodko Bango has conducted a meeting at Karkodere under the chairmanship of Sri Tajampanga Haji V. Gosang. The subject matter of Kebang was that Sri Onil Ali responded
this is petitioner number 1, son of such and such, set the fire to the house of Miss Yago Pankang. This is petitioner number 2. Daughter of such and such at the night of 23/11/2023, for which all the Garco dairy members had Kevang. Some 4,50,000 has been directed the accused to compensate the damage has been the accurately thorough. This is my little bit to the and at the same time the sum of the rupees 50,000 only has been imposed to the villager by the accused, which is a bane in our local tradition, my lord. The Kebang has decided not to assign a threatening to Miss Yago Pankam for her lifetime. If he violates, and this decision of the Kebang has decided to impose the value of 1 life, and the accused shall be put in the jail for lifetime. So, my lord, this decision has been taken, my lord. So, an impose of the Arias 50,000 has penalty of the criminal has been also imposed by the village authority.
Keba has settled the matter.
My lord. So, my lord, in view of this, my lord, this may be, my lord.
Lordship, this is the Keba decision, Lordship. Their joint, if they joint petition, their Lordship, their joint mutual agreement should be their Lordship. If they come with the agreement, that I have no issue, Lordship.
Okay, Mr. Modi, then you come with an agreement.
My lord.
You come with an agreement.
My lord, if, since my lord, no separate agreement, but that this Kebang has bind and all the formalities as per the decision of the Kebang, my lord, as petitioner number 1 has complied. So, my lord, in view of the Narendra Singh and the Lakshmi Narayan, my lord, it's cover case within the family matter. So, my lord, this can be, my lord, quash, my lord, that I'm praying for.
The Keba decision is there, but both of you should file an affidavit.
My lord.
Settlement. Stating that you have complied with all the Keba decisions.
My lord.
You file it. Mr. C. Modi, the learned counsel appearing for the petitioners, prays for some time to file an additional affidavit. I have also heard Mr. H. Lakshmi, the learned additional preview for the state of bonus police. List again on when you will file.
My lord, after 2 weeks.
After 2 weeks.
2 weeks, my lord.
List after 2 weeks.
All right.
Number 5. Yes.
My lord, based on 220 Constitution, for quashing and setting aside of the ex parte impugned judgment and order dated 28/10/2022.
Did you receive notice?
No.
You did not receive notice?
My lord, in this case,
where is the order?
My lord, will find the order in the last page. This is the impugned ex
parte order.
Impugned judgment. I'm challenging the execution order. Order dated 30 last page. Order.
Yeah, where is the impugned order you are challenging?
Last page 52.
Oh, order dated 30/06/2023.
Yes, my lord.
Judgment debtor. This is an execution proceeding.
Yes, this is execution proceeding. My lord, against this ex parte impugned judgment and order, we have filed an appeal before the State Commission, and the appeal is pending. And along with the appeal, we have filed 2 missed case applications. There is for stay of the impugned orders, judgment and order dated as well as for filing the appeal. So all these three applications are pending before the State Commission. And in the meantime, this order was passed.
You were directed to deposit 6,40,000.
Yes, my lord.
Is it a money suit?
No, yes, this is more of a money suit decree.
Original decree is a money decree. Money decree.
Money decree it is. My
Why,
lord, the-
why you are challenging?
because against this, against my lord will first see the my lord will come to page number page number 12. The respondent, they have filed one complaint, consumer complaint case number 02/2023 against the petitioner and one more.
Mr. Katu,
My lord,
I think we should go through the record.
my lord,
there is-
record has already, my lord, called for.
Oh,
Now, my lord, it is available, my lord.
it is available.
Yes, my lord. And my lord, my lord,
LCM? Yes.
my lord, very fact of the case is, my lord, this civil division petition is not maintainable. Because my lord, initially the complaint was filed before the my lord, district consumer forum. And the notice were issued to the my lord, this appellant, the petitioner, time and again. But he did not, my lord, appear before the district consumer forum, my lord. Thereafter, award was passed. And the award was passed. This was duly intimated to him for payment of the awarded amount. Thereafter, my lord, what happened? He has not taken any steps. And my lord, in the meantime, my lord, the executing court issued then in the meantime, my lord, he prepared one miscellaneous applications before the executing court, stating that no opportunity was given to me for my lord, the payment of the awarded amount. Then, my lord, that miscellaneous applications filed by him was rejected. In the meantime, my lord, he filed an appeal before the State Consumer Forum. Now, State Consumer Forum, my lord, exactly what is happening is State Consumer Forum is not functioning, is not cheating. So therefore, if it is not functioning, my lord, if he has challenged the very, my lord, the order of the my lord, the order passed by the my lord, the District Consumer Forum, the best appropriate forum is State, my lord, the Consumer Forum. Then if my lord, agreed by the order passed by the my lord, the State Forum, Consumer Forum, my lord, the next is, my lord, the appellate court is National Consumer Forum, my lord. So therefore, there is no, my lord, the scope and my lord, the
Interference by High Court.
my lord. There is a separate set of my lord, the rule, my lord, the laws. Therefore, Consumer Act has been framed, my lord. The very purpose of the enacting the Consumer Forum is something different, my lord. Now he has prepared an application under 227, my lord, supervisory power. The supervisory power, as your lordship know, then my lord, it is very limited. When there is a grave, my lord, the miscarriage of justice, my lord, when the learned court below is not having without having jurisdiction, if order is passed, then my lord, the rule 227 can be exercised, my lord. But here, my lord, the different forum is still open left. My lord, so therefore, my lord, this civil division petition is not maintainable at all.
You can go to National Commission.
Yes, my lord.
No, my lord, in the State Commission, our appeal is already admitted. It is admitted and registered and number as RF number 02/2023 and it's still pending.
It is still pending.
Yes,
Yes.
it is still
Then you
pending.
go and seek relief in the
Yes.
Consumers Commission.
Yeah, in the meantime,
High Court has nothing to do.
as of now, what is happening is that the new chairman has not come up. So in the meantime, this execution, this order dated 36/2020, thereby directing the petitioner to deposit the amount that has to be stayed in course. because the appeal is pending.
At this stage, High Court cannot do because matter is under consideration by the commission.
Right.
Yeah, because since there is no commission chairman, so we could not ask for stay of the judgment and order.
We have to wait. It is a different matter, but High Court cannot interfere because there is nothing wrong.
Yes, because
Exercising power under section 227 is difficult in this case.
My lord.
but my lord, if this order is not stayed, then it will be executed. Then I have to make the payment of rupees 6,40,000 as per the order of the Honorable Executing Court, District Court.
Yeah, order shall not be stayed. Order shall not be stayed under 227. You appear before the Consumer Commission, they will do it.
My lord, we have already filed, the appeal is pending.
There is no other way. Only Consumer Commission is the best forum. Or else you can move the National Commission.
Yes, we will move, once if we are agree with this National Commission, but since
Forum
the-
cannot be changed, my lord.
Yes.
Track cannot be changed, my lord. There is a separate set of laws, my lord.
My lord, during the pendency of the appeal, order is not squashed. Then into infractions.
If you want stay, you have to deposit 50% in this court.
Yes, I'm ready.
Ready?
I'm ready to pay at any time. I will pay. We have a very good case. At the record only I can show that this is a not,
Then
prima facie that they don't have a case.
Why you did not appear before the commission?
I did not appear because I engaged a counsel. Thereafter, I contested the case by filing the written statement. Thereafter, due to the advent of the corona pandemic, I lost communication with the engaged counsel. Thereafter, on the date of hearing, my engaged counsel did not appear, and because of that, because he did not, my engaged counsel did not appear, the matter proceeded ex parte.
No, you.
And my lord, because of the mistake of the counsel, the party should not suffer.
Now there is no other way. High Court will not interfere in these matters because the appeal is still pending before the commission. If the commission is not available here, you go to the National Commission. You apply there, they will pass necessary orders. But what High Court will do?
My lord, for a time being, this order may be stayed
No, this order
until the new chairman comes up.
no order should be stayed by the High Court. High Court will not exercise power in this matter.
Then, my lord, I have to
My
make
submission
the
is that
payment.
at this stage, my lord, this civil revision petition may be dismissed with a cost, my lord. It's because knowing fully, my lord, this forum has been chosen, my lord. This is not, my lord, this cannot be exercised under 227,
My lord, we don't have any alternative remedy. Where will go?
National Consumer Forum.
National Consumer Forum will go only once we are agreed in the State Commission. And the appeal is pending for the State Commission.
High Court cannot interfere in these
Right.
matters. Heard, Mr. Your name is T. Sunil.
Yes.
T. Sunil appearing for the petitioner. Heard, Mr. M. Kato appearing for the respondent. Respondent 1 and 2. You are appearing for
Sole respondent.
Oh, appearing for the sole respondent. Fair. The petitioner was the respondent before Consumer Disputes Redressal Forum. He did not appear before the tribunal, therefore the tribunal passed an ex parte order against him, directing him to pay rupees 6,40,000. Stop. Thereafter, he filed an appeal before the State Consumers Commission. The commission is still the appeal is still pending. Para. In the meantime, the State Consumers Dispute Redressal Forum started execution proceeding. The petitioner filed an objection.
My lord, execution was initiated by the District Redressal Consumer Forum, my lord, not by the state.
Consumer Dispute Redressal Forum or Commission?
District Consumer Redressal Forum, my lord.
In the meantime, execution proceeding was initiated before the District Consumer Disputes Redressal Forum. The petitioner objected before the forum, but his objection was rejected. Para. Now, the petitioner submits that the state commission is not working now because of non-availability of presiding officer. Therefore, the present application under section 227 has been filed, challenging the order dated 30/06/2023, passed by the Consumers Disputes Redressal Commission, Papumpare District. Para. I have considered the submissions made by the learned counsels of both sides. There is no doubt that the appeal is still pending before the State Commission. Therefore, the appropriate forum will be the State Commission, who can pass necessary orders in this matter. On the face of the record, there is nothing wrong in the impugning the order to warrant exercise of power under section 227 of the of India. It is a state commission where his appeal is presently pending for seeking redressal. With the aforesaid direction, the present civil division petition stands disposed of.
My lord, till the hearing of the petition
No,
before
no.
the state commission.
No skill.
My lord, this small
227 is difficult.
my lord, just a small correction in my lord, the award is 6,40,000 along with interest, but 6% per annum, my lord.
I don't know, 6,40,000, along with interest at the rate of 6% per annum.
Deeply obliged, my lord.
Yes.
Yeah, well, matter. Lordship, in this case,
Tapa.
yes. Kindly see FIR, Lordship. FIR is on page number 16, NHR 2.
16.
Yes. May I read the contents, Lordship?
Yes. With due regards.
Yes.
It is.
With due regards, it is to apprise you the same matter of the complaint was already submitted before your authority on dated 2nd June 2023. As it was not fully considered on some ground, hence we are submitting this joint complaint against Sri Tayam Siran, son of late T. Siran, village Lekhi, POPS, New Delhi, District of Varunachal, for cheating with false assurance to return a given amount of rupees 21 lakhs only on dated 24 August 2020 and rupees 50,000 through Google Pay in total of rupees 21,500 only, in lieu of which advance check amount of rupees 42 lakhs was given by him. That being easily fooled by him, I happened to manage the above mentioned amount from complainant number 2, that is Achubagan, on loan basis, but no action of return is committed till that, for which it is amply clear that the act of Tayam Siran is made with clear intention and motive to cheat by extracting hard-earned money with false assurance by giving his check due to his I was made to return run from post to pillar and manage the mentioned amount and compelled to give this joint complaint. Therefore, your authorities kindly register a case against under appropriate section of law. This is the FIR. Lordship, case is there, may I? I have given my this averment in this page 5, paragraph 6. What had actually happened? Page 6. This is FIR is joint FIR. Actually, this is in between the complainant number 1 and me. This complainant number 1 is Mr. Binay Thakur, who is my friend. And in need of money, I have requested him to money loan of rupees 21 lakhs. As I was in dire need of money to clear some bank loan scheme, which was pending before the Jeevan Samriddhi Nidhi, sponsored by some UP-based financial bank. So on my request, my friend Binoy Thakur has deposited the requested amount of rupees 21 lakhs in my account.
Into two?
Yes. I have promised him to pay double the amount within 6 months. That is why, in due acknowledgement of our, although there is a no written agreement, but in due acknowledgement of our verbal agreement, I have issued rupees 42 lakhs check, advance check.
You issued?
Yes, I have issued him to Binay Thakur, so that when the money is processed, I can give him double the amount as we have discussed.
No, who took the money from you? Binay Thakur?
Yes, money 21 lakhs belongs to Binay Thakur. That has been.
You gave the money to Binay Thakur?
Yes, no. I have received the money from Binay Thakur.
You have received 21 lakhs?
21 lakhs.
From Binay Thakur?
Binay Thakur. In return, I have promised him to
pay double
the amount after 6 months. That was because I was in dire need of money to invest the money before to obtain a bank financial loan. Jeevan Samriddhi Yojana.
Okay, all right. You took 21 lakhs from Binay Thakur?
Yes.
You promised him to pay double the amount?
Double the amount. Accordingly, I have, at the same time, on the day itself, I have issued advance check of rupees 42 lakhs. As discussed. And during the pendency, Lordship, my money 6C, admittedly 21 lakhs was received from, that was just transferred to my account, and from my account, I have transferred the money in the bank account from where I was going to obtain bank loan. That is why, Lordship, due to some reason, my bank loan could not be approved. And I was pursuing the money for recovery of my money also. In this period, inordinate delay has been caused. I am unable to refund this money as promised. 21 lakhs plus 21 lakhs is 42 lakhs as promised.
Then he lost an FIR against you?
Yes, he presented this money, my check before the bank concerned. And that was found to be bounced again. And if that is found to be bounced, that check is governed under the Negotiable Instrument Act. It is a 138 case. That is
okay, all right.
Yeah, that is civil nature, matter of civil nature. And still that I am always discussing with him, this Mr. Thakur. As I am stand with my commitment, I am ready to pay, but at this stage, I am unable to pay because I'm mobilizing my resource to pay the amount.
Okay, Mr. Sering, what is your opinion?
The very purpose of 438 is to protect those people against whom a false allegation has been made. The very concept of 438. But so far, on perusal of the FIR, it appears that there is a clear allegation of taking away of 21 lakhs and has not been paid till date. Therefore, my lord, at this stage, we require to peruse the case diary. But no matter, my lord.
You could have filed money suit also.
Yeah, that is alternative.
Yes, civil matter. They have alternative remedy. 138 cases there.
Heard the learned counsel, Mr. T. Tapak, appearing for a petitioner. Heard Mr. J. Singh, the learned public prosecutor for the state of Arunachal Pradesh. This is an application under section 438 of the CRPC in respect of Nirjuli PS case number 12 of 2024. Under sections 417, 418, 420 of the Indian Penal. The petitioner borrowed 21 lakhs of rupees from Vijay Thakur. Stop. The petitioner promised that he will pay double the amount, that is rupees 42 lakh, to Vijay Thakur. Therefore, at the time of taking 21 lakhs from Vijay Thakur, the petitioner issued a check of rupees 42 lakh to Vijay Thakur. Now, the petitioner could not arrange the money for different reasons. Therefore, Vijay Thakur, along with another person named Achu Bagang, lodged an FIR before police. Fair. I have considered the submissions made by the learned counsels of both sides. Mr. Tapak submits that there is a possibility that Vijay Thakur might present the aforesaid check of 42 lakhs in the bank, and thereafter he might file a case under section 138 of the CRPC, 138 of the NI Act. Mr. Singh submits that the case diary is required for appreciation of the bail period. I have considered the submissions made by the learned counsels of both sides. This court is of the opinion that the present story projected in the FIR has the elements of a civil dispute. I am of the considered opinion that the present petitioner does not deserve to be detained in custody for the present under the present facts and circumstances. Therefore, his pre-arrest bail period is allowed. It is hereby directed that in the event of arrest in connection with Nirjuli PS case number 12 of 2024, the petitioner Tayam Siram shall be released on bail of rupees 25,000 with a surety of like amount to the satisfaction of the arresting authority. The petitioner is directed to cooperate with police investigating officer as and when required. With the aforesaid direction, the present bail application stands disposed of. Item number 30. Number 50. Criminal appeal.
Lordship, we have not been furnished the copy of this petition, Lordship, or this jail appeal, Lordship.
Huh?
We have not been furnished the petition, the jail appeal copy, Lordship.
A memo of appeal.
Yes, Lordship.
You have not received.
We have not received yet, Lordship. This is the first time it is
call.
come up today, Lordship. Yes.
MSH Lakshmi D. Learned additional PP submits that she is yet to receive the copy of the memo of appeal. Under the aforesaid circumstances, the matter is adjourned today. The appellant is directed to provide one copy of the memo of appeal to MSH Lakshmi. Least after 3 weeks.
Lordship, obliged.
Item number 6. You're for 6. Huh? Item number 6.
Yeah, my lord, I'm not named in the CD or in the FIR, and
CD received or not?
yes, my lord. I've already appeared on 2 occasions, my lord.
He appeared before IO.
Yes, on two.
Your statement is recorded or not?
Already, my lord. I have given all the documents also, my lord.
Are you on interim bail?
Yes, my lord. It was regarding, my lord, some misappropriation of a Portland, my lord.
Yeah.
Portland vehicle, my lord, excavator, my lord.
He is saying he has appeared before IO.
There is no role of the accused in this case, my lord. First status report, my lord. First, fourth page, my lord. The starting from that, not that one, my lord. The front page, my lord.
Front page.
First, second, third, fourth page, my lord. The status report. The IO has given the observation, my lord.
One, two. Fourth page.
Yes, my lord.
Bail comments. Applicant is being treated as a witness.
Yes.
In this instance. He is also found cooperating.
Yes.
Okay. Heard Mr. D. Soki appearing for the petitioner. Heard Mr. J. Seri, the learned additional PP, learned public prosecutor for a state of Arunachal Pradesh. Para. This is an application under section 438 of the CRPC in respect of Crime Branch Police Station case number CB, Crime Branch Police Station case number 02 of 2023 under sections 120B, 403, 406, and 182 of the Indian Penal Code. Para. Pursuant to the interim order granted in favor of the petitioner, he has appeared before the investigating officer and has cooperated with police investigating officer. Police investigation. Today, the police investigating officer has filed a report to that effect, stating that the petitioner is going to be shown as a witness only in the instant case. Considering the aforesaid facts, this court is of the opinion that the petitioner, what is the name of the petitioner?
Riku Chandra Das, my lord.
Riku Chandra Das. Considering does not deserve to be detained in custody. His pre-arrest bail application is allowed. The interim bail order granted in favor of the petitioner by this court is made absolute. The CD shall be returned.
May it pleases my lord. Lordship can hear me?
Yes.
Lordship, my lord,
Yes,
item
yes.
7 and 8 arising out of the same FIR. And Lordship, CD was called for on the
7 and
last.
8.
Yes, my lord.
CD received or not?
Yes, Your Lordship.
7 and 8.
Yes, my lord. In respect of item number 7, Lordship, petitioners, there are two petitioners, my lord. Petitioner number 1 is the father of an accused, and petitioner number 2 is the elder brother of the accused. And in Lordship, in this case, my lord, petitioners are on interim relief by this honorable court, my lord. The FIR is of my
They
lord.
have appeared.
Yes, my lord. They have appeared.
They have appeared before the IO.
As per my instruction, they have appeared before the IO, my lord.
Ginny?
With regard to item number 7, Your Lordship, I don't have any objection if the interim bail is made absolute, Your Lordship. However, in item number 8, Your Lordship, there was no interim on the first date, Your Lordship, and the alleged accused seems to be the prime accused, Your Lordship. I have placed the CD, Your Lordship.
Okay, just a minute. In item number 8, he is not on interim.
He is not in interim, Your Lordship.
Then item number 7.
Item number 7.
Heart Mr. B. Bora.
I am T. Chakraborty, my lord.
Appeared.
I am
B. Chakraborty.
T. Chakraborty.
T. Chakraborty.
Lordship.
T. Chakraborty.
Lordship.
T. Chakraborty appearing for the petitioner. Heard
Two
MSP
petitioners.
Ginny, the learned additional PP for the state of Arunachal Pradesh. Para. This is an application under section 438 of the CRPC in respect of Nirjuli PS case number 106 of 2023 under sections 302
Lordship.
of the Indian Penal Code. Pursuant to the interim order granted in favor of the petitioner, he has appeared before the investigating officer and has cooperated with police investigation. MS Ginny has also endorsed this fact. Para. Since the petitioner has The petitioners have two petitioners.
Lordship, two petitioners in
Since since both the petitioners have cooperated with police investigation, they do not deserve to be detained in custody. Their pre-arrest bail application is allowed. The interim bail order granted in their favor by this court is made absolute. The bail application stands disposed of accordingly.
Obliged.
Item number 7 go.
Yes,
And
sir.
item
8.
If I take your lordship to page number 12 of item number 8, your lordship.
Item number 8.
Yes, your lordship. A brief fact of the case is, your lordship, deceased Nangra Mania Sangha was found dead in her apartment, your lordship.
Okay, Mr. Chakraborty, please read the FIR.
Lordship, I am named in the
Page number
FIR. I am not named in the FIR. I am reading the FIR at page 12, my lord.
Yes, yes.
With reference to the subject cited above, I would like to inform your good office that since 2 days before, Sri so-and-so and Srimati so-and-so did lots of call to deceased Nangam Neima Sangha, contact number, wide mobile number so-and-so on 14/12/2023 and 15/12/2023. But her contact number came switched off. Then both Sri Anil and Srimati Mama felt suspicious that something goes wrong, and then both persons went to deceased rent house at Nirjuli on so-and-so at evening in between 7 p.m. to 7:30 p.m. and saw that her main rent house door was locked in outside, and the deceased car also parked inside the premises of the rent, which looks very clean and not went anywhere, and her sandals, shoes were jumbled up, and both persons tried called many times her, but it came switched off, and even tried to see inside her rent rooms, but unable to see whereabouts of to her. Then Srimati Mama called to maximum family members, relatives to contact her or any information to her. Then nobody have known for any details to her, and even asked to neighbors also, but no any fruitful details were received from the neighbors. Then both persons left away the said rent house, and after I have called to Srimati Mama to look back, and in between 8 p.m. to 8:30 p.m. we broke the lock and see if any unwanted incident occur or not. Then we together reached at her rent room and saw through hexo blade, we have cutted her rent room's door lock and entered the house. Then we saw that her dead body was lying on the floor of her bedroom, and it looked someone beaten her seriously at her face and one tightly hanky at her neck, which shows that surely done murder to her with ill motive, but did not any sign of suicide, and her bed was messed up. Lordship, accordingly, this FIR, I am not named. But I admit, my lord, I know the deceased. A few years back, we had a relationship, my lord, but for the last 2 years, I am not in touch with the deceased, my lord. At one point of time, the petitioner, who has been, though not named in the FIR, the police is calling up because I used to have some phone calls and chats with the deceased lady, my lord. My heart goes out with the deceased lady, but my lord, my role, with great respect, my lord, there is nothing. And if at all is there, my lord, it's subject to investigation, my lord. But I will cooperate with the investigation. But since FIR is of 302, even if I go to the police station to record my statements, my apprehension is that I will be arrested. Lordship, may kindly protect me. I'll go to the investigating officers. I'll record my submission statements, and I'll extend full cooperation in the investigation process, my lord. I have made specific statement, my lord. I am not denying that I don't know the accused. Accused at one point of time, we had some relationship, my lord. But for the last 2 years, I am having no relationship with the deceased, my lord.
Okay, all right.
Now, your lordship is well aware that this is a case where initially there was a zero evidence, except for the fact that there was a murder which took place, your lordship. Now, if your lordship will see the CD, your lordship, I have marked it. the CCTV as well as the CDR of the deceased, as well as all her relatives were taken into consideration, Your Lordship. I've marked the CD, Your Lordship will see. In the CCTV, Your Lordship, the accused is seen existing from the place of occurrence.
What is the name?
Deep
Deep
Parme.
Parme.
Deep Parme, Your
Deep
Lordship.
Parme.
Deep Parme, yes.
Yes.
He
Your Lordship.
is seen in the CCTV.
Yes, Your Lordship.
Where?
Your Lordship, I've just marked it, Your Lordship.
Um,
The possible suspect is seen leaving from the room of the deceased.
suspect is leaving the room of the deceased and
Later
exiting from PO side
Now,
towards main highway.
now, if Your Lordship will see, subsequently from the deceased, Your Lordship, the last call made was to the prime accused, Your Lordship. Now, the CDR of the prime accused was also taken into consideration and once was sent for location of the mobile number at that point of time, Your Lordship. Your Lordship will see the second flag mark, Your Lordship.
Yes.
Your Lordship will see the bold, written in the bold, Your Lordship. The CDR reports clearly indicate the presence of the suspected person at the location of the deceased at the time of her death. Further, it confirms that they had known each other for a very long time. Now, their submission is that they did not come to the state of Arunachal Pradesh, Your Lordship. The CCTV confirms that he existed from the place of occurrence and from the room, Your Lordship.
On that day?
On that day, Your Lordship. And even the CDR, Your Lordship. CDR of his mobile number clearly shows that he was absolutely present at that point of time during the death of the deceased, Your Lordship.
Okay, Mr. Chakraborty.
Lordship.
There are some materials in the case.
Lordship, I leave it to your Lordship. I leave it to your Lordship.
It will be taken up on 19.
Lordship.
Hard Mr. T. Chakraborty appearing for the petitioner. Hard MS T. Genie the learned additional PP for the state of Assam, the state of Arunachal Pradesh. List on 19 March.
Lordship, through video, remote video conferencing, my lord.
For video conferencing, they can apply it.
You can, Mr. Chakraborty shall be heard on the day through remote video conference, RVC.
Lordship, I'm deeply obliged, ma'am.
CD shall be retained.
Also, the updated CD, Your Lordship. Updated CD, Your Lordship.
Updating is not necessary. It is already updated. You retain the CD.
Yes, Your
Till 19.
Yes.
CD shall be retained.
Lordship, I'm deeply obliged.
Okay. Okay.
Deeply.
Number 9 on the
Yeah, please, Your Honor.
37.
Your Honor,
Yes.
item number 10, Your Honor. Sangi Wangchuk. In this case.
It should be taken up first.
Yes, Your Honor. It may be taken up first because in this case.
What the matters arising out of the same
FIR. But in item number 10.
Or not?
Yes, madam.
No, on the last occasion, the interim bail was granted to the applicant here.
Interim bail was granted.
Yes.
Did you appear before the investigating
Yes,
officer?
Your Honor. The applicant appeared before the IO.
Your statements recorded or not?
It has been recorded on 27th.
Training?
Yes, madam. Recorded.
Their statements recorded.
Yes, madam.
What is the report of the IO?
You.
NDPS.
Yes, madam. Can we?
Hard MS TY Bhutia, appearing for the petitioner. Item number 10. Hard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh.
Item number 9.
Item number 9. Item number 9. It is item number 9. T.Y. Bhutia, appearing for the petitioner. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh. This is an application under section 438 of the CRPC in respect of
Rupa PS
case number 15 of 2023 under sections 20 within bracket C and 25 of the NDPS Act. Para. In item number 9, there is no interim order.
Interim is on item number 10, Your Honor, Sange
Item
Wangshu.
number 10. The first write item number 10. Heard MST Bhutia, TY Bhutia appearing for the petitioner. Heard Mr. J saying, the learned additional PP or the learned public prosecutor for the state of Arunachal Pradesh. Para, this is an application under section 438 of the CRPC. In respect of Rupa PS case number 15 of 2023 under section 20 within bracket C and 25 of the NDPS Act. Para. Pursuant to the interim bail order granted in favor of the petitioner, comma, he has appeared before the investigating officer and has cooperated with police investigation. Para. Since the petitioner has cooperated with police investigating officer, there is no necessity of detaining this petitioner in custody. Therefore, the pre-arrest bail application of Sange, S-A-N-G-E-Y, Sange Wangshu is allowed. The interim bail order granted in his favor by this court is made absolute. The bail application stands disposal. And what about item number 9?
Item number 9, similar facts and circumstances, Your Honor.
But
In
you
this
are not
case
on
as well,
interim.
because it was filed later on.
Huh?
It was filed later on. And on the last date, since this matter was, item number 10 was also pending, it was listed together.
In item number 9 and 10, both, my lord, there's a similar allegation. Allegation is that, my lord. Since allegation is that they were acting as a middleman, my lord.
Achha.
That was the only allegation.
Oh, that is the only allegation.
Yes, my lord.
My submission is that in the FIR, the names of the applicants have not been mentioned. And there is no recovery that has been made on the spot. They've not been arrested from the spot, and they've not been arrested by the police officers at that point of time. Only on the basis of the disclosure statement, they
In
were
item
arrested.
number 10, you write T.Y. Bhutia, J. Saying, public prosecutor. Para, this is an application under section 438 of the CRPC in respect of same Rupa PS case number 15 of 2023 under section same 20C and 25 of the NDPS Act. Para. Where is the FIR?
At page 13.
Huh?
Page 13. This is a complaint. FIR is at page 16.
Page 16.
Contents of the FIR is at page 18, typed copy.
18. On para. On 3/10/2023, police received an information that a vehicle bearing registration number AS01 PK 7373 was carrying some narcotic drugs. The aforesaid vehicle was accompanied by another vehicle bearing registration number AS01 DV 1112. Both the vehicles were coming towards Rupa. Police stopped both the vehicles. Though they initially tried to escape. police recovered 110 kilograms of suspicious ganja from the vehicle number AS01DV AS01BK 7373. One person named Sanjay Basumatari. The person's named Sanjay Basumatari. Dinesh Musahari. Were arrested by police. Para. The case diary reveals that the present two petitioners worked as middlemen only, and nothing was recovered from them. Para. This court is of the opinion that since nothing was recovered, since no narcotic drugs were recovered from the present petitioner, he does not deserve to be detained in custody. Therefore, the pre-arrest bail application of Nima Dorji is allowed. It is hereby directed that in the event of arrest in connection with Rupa PS case number 15 of 2023, the petitioner Nima Dorji shall be released on bail of rupees 50,000 with a surety of like amount to the satisfaction of the arresting authority. The bail application stands disposed of. CD shall be returned.
Deeply obliged.
May I please, your Lordship?
Yes.
Lordship will find the FIR at page number 11, Lordship.
Page
11, Lordship. My lord, in this case, there was a direction to furnish the case diary, but we have sent a WT message. We could not furnish it. We could not. Lordship, in that case, Lordship, I'll pray for interim, Lordship, because in the last occasion, when this matter was placed before your Lordship, no interim was granted to me, Lordship.
Okay, where is the FIR?
Lordship. Page number 11, Lordship.
Okay, you read it?
Lordship. With due regards, the team Duimok Student Union would like to lodge a first information report against one unknown person who attacked with local dao one of our central executive member of DSU, the Sri Tana so-and-so and the son of so-and-so, village so-and-so. Incident happened at Bagay Tinali near Western Bhat at around 4 a.m. Lordship. In the morning, Lordship. Now the Lordship, the gist of the fact is that, Lordship, the applicant, Lordship, he stayed in a village, Lordship. He came down to Itanagar for some medical checkup, Lordship. And on the 2024, Lordship, because this affair has been lodged in the month of January, Lordship. What happened, Lordship, on the 22nd, Lordship, before this affair was being lodged before the police station, Lordship. I went to the bar to stress out my, there was some problems was going on in my family, so I just need to relax myself. So I went to the bar, Lordship. We had a couple of drinks, Lordship. In the meantime, Lordship, this victim along with the other accused person, they were also drinking in the same bar, Lordship. And because of some dispute arise between the manager and the complainant, Lordship, regarding the payment of bill, Lordship. Then I intervened, Lordship. I tried to sort out the matter among themselves. I was under the impression that the matter has been resolved among themselves, Lordship. The moment I came out from the bar, they started attacking me. That is the main fact of the case, Lordship. Now, Lordship, because whatever those incidents happened, out of, without any provocation, Lordship, on the part of the accused person, Lordship, part of the applicant, Lordship.
The moment I came out from the bar, they started attacking me, Lordship, with the number of 6 or 7 people. Now, in order to protect myself, Lordship, we, being an archery, Lordship, we used to carry a local dog because I live in the village, Lordship.
Who is this Tana Simon?
Tana Simon is one of the executive members as allies in the FIR, Lordship. One of the executive member of the, because this FIR has been, was being filed under the banner of Duimok Student Union, Lordship. Now my...
Okay, I will give you interim protection.
Lordship.
Heard Mr. T. Gaurav, the learned additional learned counsel for the petitioner. Heard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh. Mr. Sering submits, but the case diary has not been received. Para. I have heard the learned counsels of both sides in the matter of a prayer for interim protection. As an interim measure, it is hereby directed that in the event of arrest, in connection with
Usually PS 10 of 24, Lordship.
PS case number Nirjuli.
Yes, Lordship.
Nirjuli PS case number 10 of 2024. The petitioner Pate Karu, P-A-T-E-Y, Pate Karu, shall be released on bail of rupees 25,000 with a surety of like amount to the satisfaction of the arresting authority. The petitioner shall appear before the investigating officer within next 10 days from today to cooperate with police investigation. List again
27.
on 27 for perusal of the case diary.
Obliged.
Deeply obliged, Lordship.
It is for orders. Notice served or not?
Notice written unserved.
Huh?
Notice written unserved.
Routine notice returned answered.
Yes.
What you will do now?
Your Lordship, I may be allowed some time to contact the petitioner to find out the actual address of the respondent.
Respondents 2 and 3.
Yes. 2 private respondents.
Returned unserved. Heard the learned counsel MS?
Miss Tirimi.
Huh?
Tirimi.
Tirimi. Appearing for the petitioner, heard Mr. G. Tadu, the learned additional PP for the state of Arunachal Pradesh. The petitioner is directed to take fresh steps for service of notice upon the respondents 2 and 3 by registered post with AD. List after 4 weeks.
Obliged.
Item number 13.
None appears.
None appears for the petitioner on call. Heard Mr. J. Sering, the learned public prosecutor for the state of Arunachal Pradesh. Since none appears for the petitioner on call, the matter is adjourned today. List after 3 weeks.
Obliged.
Item number 14. Notice served or not?
Yes, notice has been served. Yes, notice has been served.
Notice served.
Yes, the respondent had appeared on 7 August 2023 for his appearance. And after that, my lord, this matter was taken up on 3 occasions, but the respondent had never appeared.
Appeared.
Never appeared after that.
Okay.
They have only appeared on 7th August.
Okay, all right. Heard Mr.
L. Teni.
L. Teli.
On behalf of Mr. Jiruba, Conducting Counsel for the petitioners.
Appearing for the petitioner.
Yes.
None appears for the respondent on call.
Your Lordship, it's been already 6 months since they have appeared.
List after 2 weeks for admission hearing. It will go for admission hearing.
Yes, Lordship. Highly obliged.
Yes.
Lordship, notice has been served.
Anybody appearing?
No, even
Where is the office note? Office note dated 1 and 2 respondents, two respondents.
yes, 1 and 2. 2 is the proprietor of the firm.
Though AD card in respect of respondent, respect of
Number 1 and 2.
number 1 and 2. Though AD card in respect to respondent 1 and 2 return, no wakalatnama filed by the learned counsels. Okay, it will go for admission hearing. They might come. Heard Mr. Arkoi, appearing for the petitioners. Seen the office note dated 03/07/2024. None appears for the respondents 1 and 2. List after 2 weeks for admission hearing.
Much obliged.
Item number 16 and 16. Item number 16 and 17. 16 and 17.
Here we have to file the reply.
Huh?
Here we have to file the reply, Your Lordship. I need some more time to file.
Who filed this IA?
I have filed
You have filed this IA.
for a vacation of interim order. Lordship, I served IA on 7th January.
Okay.
And
You want time to file objection?
Yes, Your
when
Lordship.
last occasion they have sought for the time because it was on January.
Okay,
And because
one,
of this,
one last chance will be given. One last chance will be given.
may I
Hard-
pray that fixed date maybe.
Oh, yes, I will give you a fixed date. Hard MS
Tirimi.
Tirimi, appearing for the applicant. Hard Mr. R. Koyu, appearing for the respondent. The learned counsel for you are the petitioner here.
No, I am the respondent in
No, in the IA.
yes, IA in the IA I am applicant.
Hard Mr. R. Koyu, appearing for the applicant. Hard MS T. Rimi, appearing for the opposite party. MS Rimi prays for some more time to file an objection. Mr. Koyu has objected to it on the ground that the matter is a long pending one. Para. After considering the submissions made with the learned counsels of both sides, you suggest one date?
May I pray that 4th April.
4th April. Okay. The prayer is allowed. List on 4th April.
Your Lordship, interim is there, Lordship. Interim.
Interim is in the main case.
Yes, Your Lordship. In main case, interim is there.
In the main CRP, you write hard MS T. Rimi appearing for the petitioner. Hard Mr. R. Koyu appearing for the opposite party. List on 4th April. Till then, the interim order passed LS will continue.
Bless you, Lordship.
Item number 18.
Please, Your Lordship.
Yes.
Your Lordship, this is a joint application being filed by the
Your Lordship,
informant.
I'm sorry, Lordship, for interference, Lordship. Your Lordship, the additional PP is appearing, Lordship.
Okay, on Monday then.
Lordship.
On Monday or Tuesday, I will take it up. Lease this matter on 19 March. Okay, Tuesday. Next
Much obliged.
Tuesday. Item number 19.
Your Lordship, the service upon the private respondent is yet to be completed.
Service upon
The private respondent, Your Lordship.
steps not yet taken for respondent number 2. Steps not yet taken for serving sending service of notice upon respondent number 2. Yes, Mr. Tapak.
Yes, Lordship.
You take steps.
Yes, we may be allowed. I thought the step has been already taken.
Yes, hard Mr. T. Tapak, appearing for the petitioner. Hard MS T. Jenny, the learned additional PP for the state of Arunachal Pradesh. The petitioner is directed to take fresh steps for service of notice upon the respondent number 2 by registered posted AD. List after 4 weeks.
All right.
Item number 31. Yes.
May I first, Your Lordship, I have filed one IA
For what?
in regard to the modification of the interim bail, which was granted by this honorable court on 4th March 2024. Your Lordship. Actually, Your Lordship, in the interim bail order, Your Lordship, kindly see page number
4th March.
Yes, Your Lordship.
Where is the 4th March order?
Your Lordship, page number 8 and 9.
Just a minute. Oh, yes.
Your Lordship.
Court martial order, what type of modification do you want?
Actually, Your Lordship, in this order, may I read the relevant? This order shall be enforced from 18/3/2024 to 28.
From where you are writing?
Page number 2. Grant
This order shall be
enforced from 18/3/2024
to 28.
Yes, Your Lordship.
2024.
Yes, Your Lordship. But my submission is that, Your Lordship, on 18/3/2024, there is an exam of the Alice accused person, Your Lordship. And moreover, Your Lordship, the Alice accused person is in the custody, which is 72 kilometers far from the examination center, Your Lordship. So in this day, it would not be possible to attend the examination, Your Lordship. That's why, Your Lordship, prior to the examination.
Now you want extension of time?
They
Only
want to
for
have modification.
modification only, Your Lordship. Since in the order it was reflected that since this order will be forced from 18 only, Your Lordship, then it could be forced from 17 or 16 only, Your Lordship. That
It can be
my
17, Lordship, then.
17.
Lordship.
17 what? March.
17
Yes,
March, Lordship. Because 18 is the exam will going to start from 18. So earlier order, it is reflected that 18 order, there this consideration of bail was granted, Lordship. So they are modified for of the date only, Lordship.
From 17/3.
Yes, Your Lordship.
17/3 to
29. Actually, in 28, it is the last examination schedule, Your Lordship. So it could not be possible after attending the exam. That's why on 29, I am ready to surrender before
Lordship,
the.
here, Lordship, this order was from 18/3/24 to 28/3/24. Lordship, after exam, Lordship, he will be escorted back to the Lordship, surrender, Lordship. He is tries to surrender after exam, Lordship. This right after exam.
when the examination will be over?
On
28,
28,
Lordship.
only, Your
On
Lordship.
28.
That's why, Your Lordship.
Then I will make it 29.
Lordship, one day, Lordship, what to do, Lordship? After exam, he can surrender, Lordship.
After exam he can
Here,
surrender.
Lordship.
But
That
exam
prior to
will be
exam, Lordship, 17, it may be granted at no issue, Lordship.
17/3.
Lordship.
Then, Your Lordship, examination will be end on the, I think, 2 only. Then it will be take, I think, 1.5 or 2 hours. That's why, Your Lordship.
Okay. Hard MS, what is your name?
C. Iring.
C.
Iring.
Elin.
Iring.
Elin.
Iring.
Appearing for the applicant in the I. Hard MS H. Lakshmi, the learned additional PP for the state of Arunachal Pradesh. Para. In BA 09 of 2024, on 04/03/2024, this court allowed the petitioner what is the name of the petitioner?
Millie Yaram. Actually, Your Lordship, the Alice accused person was Millie Tadik.
Petitioner Miss Millie Yaram to go on interim bail.
No, Your Lordship, for the
Millie
Alice
Yaram is the
accused person,
applicant.
Millie Tadik.
Oh,
Millie Yaram was the applicant.
Millie Tadik to go on interim bail. It was further directed that the interim bail order shall continue from 18/03/2024 to 28/03/2024. Para. Now, by filing the present interlocutory application, it has been submitted that the petitioner has to appear before the examination after traveling a long distance. Therefore, the bail order should continue from 17/03/2024 to 29/03/2024. Para. I have considered the submissions made by the learned counsels of both sides. The modification is allowed. The aforesaid interim bail order shall continue from 17/03/2024 to 29/3/2024.
Thereafter, the accused may be surrendered, Lordship, before the trial.
Okay, after that, the petitioner shall surrender before police.
Accused, Lordship, accused.
The accused. After that, the accused, Mili Tadik shall appear before the
Surrender before the trial court.
surrender before police.
Trial court's Lordship. Trial court.
Or surrender before the trial court. The IS is disposed of accordingly.
Or to the Lordship, the police authority, Lordship. The Lordship, concerned Lordship, authority, Lordship.
Actually, Your Lordship, this, in the order, it is reflected that, that the bail bond should be also executed before the, learned trial court. But
Okay.
Your Lordship, actually, the matter is not in the stage of that,
It is in the trial court.
But Lordship, last order, Lordship, it is thereafter the accused has surrender before the trial court again, Lordship. It is there, Lordship.
that's why.
Order they appear before the trial court.
Lordship.
Surrender before the trial court.
Lordship.
Yes.
Obliged, Lordship.
Yes.
My lord, with regard to item number 3, my lord.
Hmm.
My lord, after perusal of the roster, my lord,
Hmm.
the only available that Justice Nair is till 18. This week only.
Hmm.
So, my lord, since this matter is
Who had the matter? Justice Naya had?
yes, Justice Nair. And the issue here is my lord.
Then on Thursday,
Yes, Thursday, my lord.
make it Thursday.
Yes,
Thursday, what will be the date?
Thursday it will be, my lord.
20.
This week, my lord. Thursday
14.
14. Yes.
Thursday 14.
Yes, my lord.
You tell the 14, make it 14.
My lord, let it be through registry, my lord.
Okay.
Through VC.
Through VC.
Yes, my lord.
Okay, for that, separate order is not required.
Yes.
Anybody can appear before the
Yes,
court
yes.
by VC.
Deeply as well.
Who will appear in the VC?
B Kosik, Vedanta Kosik.
All right.
Most obliged.
Okay.